All right, this lecture is covering the materials in chapters 7 and 8 of the textbook. A little bit confusing here because chapter 8 of the textbook deals with chapter 7 of the bankruptcy code. So if I misspeak at some time, it's because of that. All right, chapter 7 deals with some basic definitions that are contained in section 101 of the bankruptcy code. The text in this case is self-explanatory, and I'm not going to go over all of the definitions in the textbook. And make sure that you read the textbook carefully and have a basic understanding of these important definitions. One of the things I wanted to point out, some things we've talked about before, is the definition of current monthly income. We discussed that in connection with the means test. And again, this is one of those instances where the definition doesn't really reflect reality. Current monthly income, as noted, is used for purposes of the means test in Chapter 7 cases, and it includes the debtor's average monthly income from all sources in the 6 months preceding the filing of the bankruptcy case. So again, we're focusing on average, not actual. So current in this case does not mean actual. All right. Domestic support obligation is something that will become important later in the class when we talk about debts that cannot be discharged in bankruptcy. And again, it's important to understand that this includes what we would think of as alimony. It's not a term used in California, but rather spousal support or child support are included in the definitions of domestic support obligation. Individual with regular income, again, this will come up in connection with Chapter 13, and it's a defined term that is a prerequisite to filing Chapter 13 bankruptcy relief. I wanted to talk a little bit about the concept of a lien. A lien is defined in 10137 as a right to property to secure repayment of a debt or the performance of an obligation. This is kind of a long way of referring to concepts that most of us are familiar with. If you buy a car and finance it, you pledge the car as collateral for the loan. That's the pledge in that case is a lien. So if you fail to pay the car loan, the lender can repossess. Similarly, if you buy a house and you finance the purchase of it, you give the lender a deed of trust on your property. That's the term we use in California. Other states use the term mortgage. If you fail to pay the loan, the lender can foreclose on the deed of trust. Liens can be created 3 ways. The most common way is the ones I've just referred to is the one that's given voluntarily. If you pledge your car for a loan, we call that a security agreement. The lien for real property in California, again, that's a deed of trust. So we call those consensual liens. The second type of a lien is what is called a judicial lien. And this is a lien that arises out of a judgment. So if I obtain a judgment against someone and I can have the clerk of the court issue what's called an abstract of the judgment, that abstract is recorded in the real property records of the county, and that would create a lien on any real estate owned in the county. So that's an example of a judicial lien. The third type is what we call a statutory lien. And these are liens created by the law and not by a court order or not by an agreement. Most common type of statutory lien is a mechanic's lien. So if you hire somebody to do work on your house and they're not paid under the statute, if they follow certain procedures, they can get a lien on your house. Another type of statutory lien is a tax lien. If you fail to pay your income taxes, the state or the federal government, as the case may be, has the right to record liens. There's no judgment. There's it not voluntarily given. Another kind of statutory lien is a mechanic's lien on an auto. For instance, if you do work, have somebody do work on your car and you fail to pay the garage, they have the right to retain possession. So again, liens are a very important concept in bankruptcy, and we'll be dealing with them throughout the class. Again, make sure you understand the other definitions. As I said, I'm not going through them in any detail in this lecture. The next lecture will deal with Chapter 8 of the textbook, which again covers Chapter 7 of the Bankruptcy Code. So let's turn to that. All right. The material in Chapter 8, the summary of Chapter 7, is really just an introduction to most of the things that we're going to be talking about later in the semester. Again, most but not everything will be described in greater detail in other chapters. The text focuses on consumer no asset Chapter 7 bankruptcy. And the reason we do that is by far and away the most common type of bankruptcy case that is filed, and most of the key concepts that apply in consumer Chapter 7 cases apply as well in other types of bankruptcy cases. It's important to understand that the term no asset simply means that there are no assets available for the trustee to administer and distribute to creditors. It certainly does not mean that the debtor does not have any assets. As we'll see later in the semester when we discuss exemptions, the California real estate exemption has been loosened up considerably in the last few years, and a debtor can, depending on the county you live in, can have roughly $700,000 of equity in a house and keep that equity when they file a Chapter 7 bankruptcy. So again, the debtor is coming out of the bankruptcy with substantial assets. When we use the term no asset, it just means that there's nothing that the trustee can seize to benefit creditors. So another way or the trustee could not seize assets is if the assets were pledged as collateral for a loan. So again, the debtor has the asset, it's just secured. The asset serves as security for a loan and is not available to the trustee. And again, exemptions are one of the most important aspects of bankruptcy. Exemptions are defined in statutes and generally protect property that an individual debtor may keep. Exemptions exist outside of bankruptcy as well. If you have a judgment against you, there are many exemptions available to debtors. And indeed, as we'll see, most of the exemptions that are available to debtors come from the law of the state where the debtor files bankruptcy. So this is one of the ways that state law has an impact on bankruptcy because the exemptions vary from state to state. An extreme example of that would be the unlimited homestead that's available to residents of Texas. So as I said, California homestead exemption for real estate, roughly 700,000. It's up or down depending upon the county you live in. In Texas, it's unlimited. So again, exemptions are a primary form of relief that's available to a debtor in a bankruptcy case. The goal is in filing a Chapter 7, if possible, is to make it a no asset case and having the debtor keep all their property. The other primary legal relief in bankruptcy is the term discharge. And a discharge is simply the end result of the bankruptcy proceeding, the court order that relieves the debtor from all dischargeable debts. Not all debts, as we'll see, are dischargeable. As I mentioned, debts for domestic support obligations are not dischargeable. And there are other types of non-dischargeable debts that we'll talk about. But the discharge, the court order, again, it relieves the debtor from personal responsibility for the debt and operates as an injunction that prohibits the creditor from pursuing the debtor personally for the obligation. It's important to understand, though, that a discharge does not wipe out a lien on an asset. So again, you buy a car, you finance it from Honda Finance. That car may be completely exempt, and you may indeed have equity in the car, but the discharge does not wipe away the lien that Honda Finance has. What the discharge does, it relieves you from personal responsibility for the debt. And the distinction is that if Honda Finance were to say after your bankruptcy was filed, Honda Finance were to seize the car and sell it and get less on the sale than the debt was owed, you would not be responsible for that difference, for the deficiency. So the discharge is wiped off your personal obligation, the liability for a deficiency, but again, does not wipe away the lien. So again, that's one of the discharges, the second one of the three elements of relief in the bankruptcy code. Another thing about a discharge, again, it's imposed by statute, and creditors used to put into loan application, and this is many, many years ago, provisions where a debtor agrees that they would not file bankruptcy and that the debt could not be discharged. Again, these types of provisions are illegal and do not have any effect. The third element of debtor relief, besides discharge and exemptions, is the automatic stay. And the automatic stay, again, we'll have a whole chapter on that, basically stops almost all debt collection efforts once a debtor files bankruptcy. Again, as we'll learn, there are exceptions to the automatic stay, but for the most part, debt collection activities must cease once a debtor files bankruptcy. Taken together, the automatic stay, the exemption, and discharge amounts to a fresh start. And that is what the debtor achieves out of bankruptcy, or I guess you say what the debtor hopes to achieve out of bankruptcy. As we'll learn, again, not all debts are dischargeable, and the automatic stay can be terminated, and not all assets are exempt. But ideally, those three things would come together and result in a consumer Chapter 7 no asset bankruptcy case. Okay, the textbook discusses at length the a process of employment and compensation of professionals. And the term professionals includes accountants, attorneys, appraisers, real estate brokers, and indeed the bankruptcy trustee. And generally, anyone who receives payment from a debtor for bankruptcy-related services, or who is to receive payment from the bankruptcy estate, assuming that there are assets that can be distributed. Prior to filing a bankruptcy case, attorneys are required to make certain disclosures to their clients. And these disclosures are part of the Chapter 7 petition package. We'll look at those later on. This process is regulated by Section 527 of the bankruptcy code. Another restriction or regulation of lawyers is there must be a written fee agreement. And this is part of Section 528 of the bankruptcy. And in connection with that and connection with the disclosures, attorneys are required to file a statement of compensation that they've received in a bankruptcy case. And again, if you look in the Chapter 7 package, it includes that statement. It's a statement that's required by Rule 20106, and we'll look at what examples of those later. Anytime a professional is hired and is going to perform services on behalf of a debtor in a reorganization case or a trustee, the employment of that professional must be authorized by the bankruptcy court. And it's a fairly routine process. The courts have form applications for employments that discloses the need for the services, the compensation, and the compensation that will be paid. Another aspect of the application and one of the requirements is that the professional cannot have a conflict of interest. And a conflict of interest could arise, for instance, if a professional had represented a creditor and now is seeking to employment as, say, by a creditor's committee. And the text talks about what can be done in that situation. There is frequently litigation in high dollar bankruptcy cases about an attorney's application for employment on the grounds that they may have represented the debtor or affiliates of the debtor before they filed bankruptcy, and that some of the legal advice given may have been perhaps questionable or putting them in conflict of interest. Again, that can happen in high-end bankruptcy cases. As the slide indicates, all fees must be approved by the court, and the text talks about the process of filing fee applications. Again, you really need to read the text carefully to discuss this process. The court does regulate payments and will pass on in fee applications and actually review the fee applications very carefully. One of the things that the court would be looking for instance, in that fee application, is this work that's being charged by a lawyer, could that work have been performed by a paralegal at a lesser fee, saving money to the bankruptcy estates. And again, as we'll learn, the Office of the United States Trustee, in addition to the court, is involved in reviewing these fee applications. In large bankruptcy cases, these are typically reorganization cases, attorney's fees literally can run into the millions of dollars a month. And in those kind of cases, the attorneys are not expected to perform work and not get paid until the end of the case, which might be 2 or 3 years down the line. They're allowed to file what are called interim fee applications. The bankruptcy code and rules contemplate quarterly fee application. But again, in some of these huge cases where millions of dollars a month are being charged in attorney's fees, in some of those situations, the court will allow for monthly interim fee applications. And in those interim fee applications, the court will typically allow 70 to 80% of the fees to be paid, reserving the balance to be paid at the end of the case. Chapter 7 trustees are paid according to Section 326. And if you review the textbook, you know that's it's a percentage of the assets that the trustee administers. And again, the trustee's fees still have to be approved by the court, even though it is a statutory percentage. There's been litigation about the percentage to be paid to the Chapter 7 trustee, and the case went literally all the way to the U.S. Supreme Court, and it held that essentially when the trustees filing their fee applications, we look at the net value of the assets that they're administering for purposes of determining compensation. So, for example, if we had $1 million piece of property and it had an $800,000 mortgage on the property, and the property was sold, and the trustee was able to collect $200,000, the trustee's fees would be based on that net value, the $200,000, not the $1 million gross value of the property. And those of you who've taken probate classes or are familiar with probate administration know the rules to the contrary, at least in California. And attorneys and estate fiduciaries are paid on the gross value, but not in bankruptcy. Another thing that's discussed in the text at length, and it deserves emphasis, is that in a no asset bankruptcy case, the Chapter 7 trustee performs work, but they're only paid $60 for that. And basically, that $60 comes from the filing fee that's charged when the bankruptcy case is filed. I can guarantee you a trustee does not make money on that $60. They take these cases hoping to get a good case, the 5 out of 100 cases that are asset cases that they can really make money on. So the $60 basically goes towards paying the trustee's overhead. And typically, the Chapter 7 trustee is going to have a staff that assists him or her in doing their work. Almost always a paralegal that will work up the case at the beginning based upon a checklist that the trustee has prepared, and assist the trustee in reviewing the bankruptcy schedules. Paralegals would do, in reviewing the schedule, it involves a detailed examination of the schedules, seeing if there's any potential assets, seeing if there's omissions in the schedules. Are they complete? Another thing that the paralegal would do, for instance, is cross-reference tax returns with the bankruptcy filings and see if they match. A tax return, for instance, may disclose rental income from rental real property. If that income is disclosed, the person reviewing the schedules, the paralegal or the trustee, you're going to look at the bankruptcy schedules. Is real property listed in there? If not, the trustee is going to ask questions, why? Similarly, similar thing with respect to interest income. If the tax return shows interest income, is the bank account disclosed in the schedule? So again, it could be a lot of work to do that. The text talks about the regulation of bankruptcy petition preparers. Bankruptcy petition preparers are regulated by Section 110A of the Bankruptcy Code. And it refers to somebody other than the debtor's attorney or the attorney's employees, in other words, paralegals, who prepares for compensation a document for filing with the bankruptcy court. A typical bankruptcy petition preparer is a storefront paralegal or bankruptcy assistance service that files or prepares bankruptcy petitions. As we know from our study of the paralegal profession and California regulations, these people are not acting legally as preparers or as paralegals. In California, the definition of a paralegal in Business and Professions Code 6450 says that a paralegal works under the supervision of a lawyer. In other words, a paralegal cannot contract directly with the consumer of legal services. So again, these bankruptcy petition preparers are not what we define as a paralegal, although they may market themselves as such. If one of these bankruptcy petition preparers explains a form or recommends a form, that constitutes the practice of law. And it's important to understand that even though 110 regulates them, it does not authorize bankruptcy petition preparers to practice law. And I put that in bold in the slide. It simply regulates their practice. And again, in my view, all of these bankruptcy petition preparers are practicing law, whether they say it or not. They're certainly explaining what these forms mean, how to fill them out, which constitutes the unauthorized practice of law. But again, it is what it is. There is some regulation and sometimes there'll be actions brought against them, but it's kind of the Wild West out there, and a lot of people are taking advantage of them. Section 110A, if you go through the textbook, it notes that there's 8 requirements regulating these bankruptcy petition preparers. And I'm going to go through them very briefly. They're on the slide here. 1, the preparer is not allowed to execute documents on behalf of a debtor. In other words, the debtor has to sign them. 2, the preparer shall not use the word legal or any similar terms in advertising or advertise under any legal category, for instance, in the yellow pages or a newspaper. 3, they cannot collect or receive payment for court fees. So the court fees have to be paid directly by the debtor. They can't be paid by the preparer. 4th, the preparer is required to file a declaration under penalty of perjury disclosing any fees paid to them or promised to be paid. 5, the preparer must sign the document and include the preparer's name and address. 6, prepare a notice to the debtor prior to the preparation of documents saying that the petition preparer may not give legal advice. 7, the preparer shall include the preparer's social security number on that document. This is, really to discourage this kind of work. And finally, 8, the preparer shall furnish the debtor with a copy of the document not later than the time the document is prepared. So again, extreme restrictions on their services. If we go to the website of the Central District of California Bankruptcy Court, if you go down to the bottom of the website, there's actually a list of enjoined petition preparers. And so these are people and businesses that have been identified by the court, and injunctions have been issued against them to stop doing this nonsense. And the significance of that, sometimes there can be fines, but they can also be punished by contempt of court if they ignore that that injunction. Okay, this slide again deals with unauthorized practice of law. And again, part of the definition we have in the bankruptcy code actually includes its own definition of an unauthorized practice of law in addition to what I previously mentioned. And this includes things like what kind of bankruptcy case the debtor should file. Should they file a 7, 11, 12, or 13? Again, most people go to these petition preparers seeking just that kind of advice. These can be very technical concepts, and they're paying good money to these petition preparers, and they expect to be told what kind of bankruptcy case to file. Again, it's completely improper under Section 110E. Similarly, the petition preparer is not allowed to explain what debts will be discharged and what debts will not be discharged, and whether or not the debtor will be able to keep any property. So again, all of these things are frequently ignored by these petition preparers. Again, this is the kind of advice people are paying them for. Further, concerning the tax consequences, property, etc. So again, all of these things are defined as unauthorized practice of law. Okay, the basic Chapter 7 process is summarized in sections 121 to 125 of the textbook. And there's a timeline on section 121 of the text. And it's a good summary. Again, once the bankruptcy petition is filed, the court immediately files or appoints an interim trustee. And the slide indicates, and this is true, that that interim trustee is actually appointed by the Office of the United States Trustee, who maintains a panel of trustees, and cases are randomly assigned to the panel of trustees. These panel trustees are contained in a database in the court. So when the case is filed, one of the trustees is randomly appointed. And the interim trustee is responsible for the bankruptcy estate prior to the first meeting of creditors, or we call the Section 341A meeting. This is the meeting of creditors. It's required under the Bankruptcy Code. When the case is filed, the court will send a notice to creditors, to the debtor, and to the interim trustee, advising them of the filing and the appointment. This notice will set forth the date, time, and place of the creditors' meeting, and also will contain deadlines, when deadline to file claims, for instance, deadlines to file objections to exemptions, and deadlines to file objections to the debtor's discharge. All of these are contained in that basic notice to creditors. At the 341A meeting, the creditors meeting, there's a meeting. Historically, these meetings took place, they were live face-to-face meetings, and this really prevailed up until COVID. And at that meeting, there was no judge present, but there are, the meeting was presided over by a Chapter 7 trustee. That would be the interim trustee, and at which point the interim trustee would become the permanent trustee unless creditors elected another trustee. At the meeting of creditors, the trustee and the creditors may ask questions of the debtor concerning the debtor's financial affairs. And again, very brief examinations. Part of the reason the examinations are so brief is that typically there's about 10 of these meetings set per hour. And they really don't have time to get into a real in-depth investigation, although some cases do, which causes the calendar to be backed up. If it becomes out of hand, the trustee typically would adjourn the meeting and reschedule it to be continued at a later time. Or if a creditor were asking questions, the trustee may encourage the creditor to file an application to examine the debtor under Bankruptcy Rule 2004, which we'll discuss in a minute. There's an excellent short video from the Bankruptcy Court's website that I'll be showing you that briefly describes what happens at a creditor's meeting. As I said, things changed after COVID. And during COVID, we stopped having in-person 341A meetings, and they were held either on the phone or by Zoom. And now in the Central District of California, unless there's some extraordinary reason, all these creditor meetings are now held by Zoom. And part of the process at the 341A meeting is that the debtor is required to prove who they are. They need to provide evidence, a picture ID, and also evidence of their Social Security number. And again, that was something that used to be done in person. Now that's something that's provided to the trustee before the creditors meeting. And if the debtor is unable to provide, for instance, proof of their Social Security number or their ITIN number, that meeting will either be, typically would be continued to a later date to allow for the debtor to do that, or the case could end up being dismissed. Again, in most of these cases that we're dealing with, there aren't any problems. And if it's truly a no asset case, usually the discharge is entered within 60 to 90 days afterwards. So again, that's just a basic overview of the process we'll be talking about in more detail. As I said, that Rule 2004 examination allows the trustee or creditors to examine any person under oath concerning the debtor's financial affairs. So it could, again, we could have a 2004 examination of the debtor. We also, if we think that there was some improper transfers made, maybe fraudulent transfers, a Rule 2004 examination could be conducted to examine the person that made or received the transfer. And really, as the text points out, it really is kind of a pre-filing deposition. It allows the trustee or creditors or the debtor, as the case may be, to obtain testimony under oath before filing a lawsuit. And the whole idea behind that is, again, to discover whether grounds exist for a lawsuit prior to filing. So again, we'll talk about the 2004 process a little bit more later in the class. Finally, the concept of reaffirmation of a debt. The reaffirmation is a process whereby a debtor agrees to remain legally liable for the repayment of a debt that is otherwise dischargeable in a bankruptcy proceeding. And as the text points out, this is a process that is highly regulated, and for good reason, because creditors used to lay traps for debtors to try to make them personally responsible for debts after bankruptcy. So again, the example I gave you earlier about a car loan, again, say you had a car that was worth $10,000, but you owed $12,000 against it. If that car was repossessed by the creditor after bankruptcy, and the creditor sold the car for $10,000, and you owed $12,000, the difference that you owed them, the $2,000, will be discharged. Reaffirmation is the debtor's agreement that says, I recognize that I have the ability to discharge this. However, I want to remain personally liable for it. So why would somebody do that? We'll talk about it in a little bit more detail later in the semester, but just briefly, oftentimes if people are in that kind of situation, maybe they're current on their car loan. They just happen to be underwater on it. And again, not an unusual situation where people owe more than the car is worth. However, if they reaffirm the debt, the carrot that's handed out to them by the creditors is that the creditor will report that debt as being a current debt to the various credit reporting agencies. And by doing that, the debtor is able to reestablish credit very rapidly after filing bankruptcy. And that process of reestablishing credit will help the debtor with their fresh start and have the ability to obtain more credit in the future. So that's typically is done to bump up somebody's credit rating. Again, we'll talk more about the whole process of reaffirmation later in the class. Okay, this is the end of this video. Again, I hope you found it helpful. It's not a substitute, of course, for reviewing the chapter. The chapter, again, is very self-explanatory, I think very well written, and a good introduction to the rest of the class. All right, this ends this lecture.